Hello, everyone. Welcome to Court with Krissy. Denial's not just a river in Egypt. I think it's also flowing through Wisconsin. Watch as Judge Mogan sentences this grandma back to prison. I hope you like it. Court with Krissy is now in session.
We will go on the record in the matter 22 CF 25424 CF 101, State of Wisconsin versus Stephanie Current. The state appears through Assistant District Attorney Kevin Schmidt in person. We have Stephanie Current appearing in person in custody with counsel Michelle Erdman. We're set here today in this matter for the sentencing portion of this case. Ms. Current pled guilty to operating with restricted controlled substance, fifth or sixth with minor passenger under the age of 16, as well as 2 felony bail jumps on September 10th, 2024. The court ordered a pre-sentence investigation report. The court has reviewed that report as well as the recommendations in the report. For the record, the court does note that at first the court was a bit confused because it noted Ms. Current's name as Stephanie Bogat in the report. And so I am not quite certain if her legal name is Current as it is noted in the criminal charges, or if it is Bogat as noted in the pre-sentence investigation report. But I did not note any other, I believe, corrections or modifications of material nature that jumped out to me or I would be aware of. Mr. Schmidt, did you receive a copy of that pre-sentence investigation report?
I did. I have one correction. They list the offense as the OWI 5 or 6 with minor in vehicle, which it got amended as part of the plea agreement. And they also list the minimum penalty for that is a period of confinement on the bifurcated sentence of not less than 6 years, which appears to be just plain mistake because that's not what that wouldn't be consistent with what they recommended. So I think they maybe just forgot to edit that.
Not less than 6 years. Yes, I believe that is also noted. Ms. Erdman, did you receive a copy of the pre-sentence investigation report?
We did, Your Honor.
And did you review that with Ms. Current?
I did.
And did you note any other corrections or modifications of the material nature to state and note for the record?
Your Honor, the name correction, they had used, there was a prior PSI completed by Ms. Current, and I'm not clear when that was, but that's her former name. Today it is Current. The next thing that we noted was indeed consistent with the state's recollection. So just so that we're all aligned, it's a OWI 5th or 6th minimum penalty or minimum incarceration of 1.5 years, right, without the enhancer. And then she's obviously got the 2 felony bail jumps, and those I believe each have a maximum of 3 and 3 is I think how that breaks down.
All right.
Just so that we've and then in terms of
the error as to the 22 CF 252 count 2 for the maximum penalty.
I don't even know how they reached 6 years because that's not even the minimum of what she was charged with. That's super weird.
I'm not clear on
I'm not
all
clear
of that,
as to that either.
but at any rate, I did go through this with Ms. Current, and Your Honor, on page 3 at the bottom under defendant's version, the very last line, it says that she's got a motorcycle group. She just wants Your Honor to be aware that this is not a gang or it's just people that she knows that ride motorcycles. Top of page 4. There was a statement that the daughter refused to take the defendant to the hospital because she thought the defendant was consuming alcohol and using substances, and then the word again appears, and she said that should be stricken. Oh,
I know where they got it. They got that from the original criminal complaint where it originally charged the 7th, 8th, or 9th with a minor in the vehicle. So sorry, go ahead.
That's fine. So, the next line in that, at the top of page 4, again, still, in that top box, it says, the defendant left and drove to Tim's house. She was stopped by law enforcement in Siren, who noted she had swerved, and then it says off the road. She said that's not accurate. They noted she crossed over the center line. And then she made a commentary here that at the time that she was driving during that incident, she did not know that her driver's license was canceled. And I believe she had gotten some assurance from oh, I'm sorry, that's something else. So that was her comment there. On the next page, page 5, does it say Tim car going to the junkyard? What was this about the junkyard?
He took out the device because
Oh, okay.
I
I'm
was
sorry.
responsible for
So
it. and I
for the
used it.
OWI,
That's not on the record.
for the OWI on the top of page 5, Judge, there's a OAR without an interlock device that she pled guilty to in 2024. I believe is a part of this actually. And her commentary was that Tim, who's in the courtroom, had removed the interlock device because the car was being towed to the junkyard following this incident. The car was totaled out, so the IID device was removed from the vehicle so that the charges would continue to accrue. The next thing that she noted was on page page 16, Judge, under the heading of sexual behavior, there's a statement from the PSI that was previously completed, some reports of assaults, and she denies those today. So that whole section should be stricken. The line on page 17, speaking to her cocaine usage at the age of 20, the statement was made, she estimates using less than a gram when she would use and would snort it. And she said that she doesn't understand what a gram is. She isn't able to differentiate that. All she knows is that it was a line and she would snort it. So that's the correction. And then the agent's impressions on page 23, the third paragraph, these are obviously impressions by the agent. She affirmatively denies that she has anger issues or poor coping skills. And in fact, she would assert that she has exceptional coping skills. And then the next paragraph, there was a statement about the methamphetamine and benzodiazepine, and she admitted to law enforcement the day of the accident she had snorted a white powdery substance. And the report says a day prior to knowing, or prior to not knowing what it was. She says that that was 2 days prior to the incident. And then again, that bottom paragraph on page 23, where she's characterized as having impulsive behavior and poor decision-making skills, she indicates to the court that she does not believe that that's an accurate statement. And that's all the changes that we have, Your Honor.
All right, thank you. All right, Mr. Schmidt, we will proceed with you with argument and sentencing recommendation.
Thank you. Judge, with this case, we have a 65-year-old woman who has been convicted of OWI 5 or 6 and a couple felony bail jumps. In the instant offense, Stephanie Current used Xanax and snorted a white powder given to her by a biker friend before getting into a car with her 2-year-old granddaughter and got into a car crash. The blood confirmed the presence of Xanax at 170 nanograms per liter and methamphetamine at 120 nanograms per liter and amphetamine at less than 40 nanograms per liter. The therapeutic range for methamphetamine, according to clinical lab reference manual, is 20 to 30 nanograms per milliliter, making Stephanie's 3 to 4 times the therapeutic level. Normal dose for aprazolam is supposed to have a 5 to 25 nanogram per milliliter for therapeutic base. That's what the Xanax is, with high dose aprazolam therapy having a resulting range of 25 to 55, meaning the blood level of the Xanax was also quite high. Current contends that she didn't cause the crash, and so she can't be blamed. That's the impression I've gotten from the numerous hearings we've had, going all the way back to when Dan Chapman was the attorney, from the comments she's made in the PSI. My take on it is it appears that her main problem with this conviction isn't a disagreement about whether she used the drugs, whether she was driving, anything like that. She believes she was rear-ended due to no fault of her own, that the person behind her was driving poorly. Should be noted, the person behind her indicated she was driving erratically to law enforcement, stopping and starting suddenly without reason. Regardless, getting drawn into the debate of who is at fault is irrelevant to what this offense actually is. That's not an element. The point is, her disagreement is that she didn't feel intoxicated. She didn't feel impaired. That's the thing we've been seeing over and over and over in the PSI, in her words to law enforcement at the scene, in court. Reading from her PSI, I get the impression she didn't think a single bit about the danger she was putting her granddaughter in, herself in, the public in, because she didn't think she was impaired. She mixed prescription medication Xanax with unknown white powdery substance from a biker friend, which turned out to be methamphetamine, and she didn't think she was impaired. That's a big problem because that shows a lack of insight. That shows extremely poor coping, especially with the history of substance abuse. That she doesn't see how she's putting all these people in danger. That she doesn't see how she continues to kill herself by doing things like that. How you destroy your own kidneys and liver when you're taking prescription medications, and then biker friend, unknown powdery substance. Why not? When I'm talking about substance abuse, what's important to look at with Ms. Current, I'm not just talking about alcohol, which has been a problem in the past, or the methamphetamine. I'm talking about the prescription medications. Just because you're getting something legally from a doctor doesn't mean you can't kill yourself or someone else with it if you don't use it responsibly. Judge, I'm actually going to be recommending a higher sentence than what DOC recommends. I'm recommending 4 years initial confinement, 4 years extended supervision on the OWI, and then 3 in, 3 out on the bail jumps concurrent to that. DOC recommends effectively double the mandatory minimum what Current was convicted of. The 1.5 is what it is as the minimum. I think DOC looked at this and appeared to recommend the mandatory minimum of what she was charged with prior to the offense, prior to the amendment of the information, because there was a child there and because of the past history of non-adjustment and the fact that, you know, she's had a lot of past OWIs and a lot of failed treatment attempts. I have a number of problems with taking that sort of a simple analysis that I think DOC did. First is really predicated upon public protection and incapacitation. When we read the PSI, we see a trend of Current moving away from alcohol and into these prescription medication and drug abuse. The OWI she beat at trial in Washburn County in 2016 involved her. She failed fields. Police drew her blood showed morphine, Prozac, and Valium. She wasn't convicted of OWI. I'm not saying the court should consider it as a conviction for OWI, but it's another situation where a lot of prescriptions in her system and she wasn't able to do fields. Her Burnett County 2020 DC, drinking margaritas after Xanax, Prozac, and Abilify, combining alcohol with prescription medications. That trend of obviously not using prescription medications as she's supposed to is there, of endangering people under the influence of them. That, when you see happening now at 65 with the past history of drug abuse, the past history of alcohol, should be deeply concerning. The PSI details her treatment history, and she fits all 3 categories. She's completed treatments, she's failed treatments, she's refused treatments. Regardless, what you conclude from that, she's done probably near everything we could imagine. The PSI compass weirdly says she's low risk to reoffend, which I don't understand how you can reach that conclusion when the conviction is OWI 6, because you already have the trend of at least 5 beforehand. Her last 2 convictions, both being OWI 5 or 6 previously. Especially in a situation where the defendant appears to mitigate or deny responsibility because they didn't feel impaired. DOC alluded to this in its conclusion, despite the compass analysis, because they noted polysubstance abuse. They noted that there was mitigation. They noted lack of insight means doesn't comprehend the danger she's putting people in. That's what they're also referring to with the lack of coping skills. You can't say someone has good coping skills when they're just biker person presenting you a line of white powder. Do it, sure, don't even ask what it is. That's not good coping skills. That's atrocious coping skills. I think that Stephanie Current has absolutely no insight into how her substance abuse problem is, how it affects her, and how it affects other people. I don't see how you could come to a different conclusion based upon the facts of this case and her past history. Well, in bond even, she continued to drive, and there was poor jumping for that. It wasn't even just stopped for an equipment violation. To be blunt, what I'm getting is whatever rehabilitative potential I think she has is grossly undermined by her failure to rehabilitate over the decades that she's had this issue. I'm sure she and her attorney are chomping at the bit to say how this time's different, just as I'm sure the past OWI she did in front of all those judges. But on that topic, I want to talk about the past OWIs. I have a problem with the 3 and 3 out recommendation of DOC because it's just not proportional when you look at the past sentences. Her last 2 OWIs were both OWI 5 or 6s and Barron. One was Barron 11 CF 413. That one, they somehow did 6 months prison, 6 months extended supervision. She filed a motion at some point to be sentenced to probation with 6 months conditional jail at Huber. It's been over a decade. She still hasn't paid the fine on that. So that sentence isn't even fulfilled. The other OWI 5 or 6, 2008 CF 298, she got 3 years probation with 1 year conditional jail on that. She wound up getting revoked because she committed an OWI while on probation. She got sentenced to 2.5 and 3 out, has not paid the fine on that either. I don't believe going only 6 months higher than the last OWI is proportional when we have an offense with aggravating factors present. The aggravating factors being there was an accident. There was a child in the vehicle who was 2 years old. There is denial of responsibility or mitigation. The complaint that I didn't think I felt impaired. There's an utter lack of insight here that says to me this is highly likely to happen again, and that there is a need for both specific and general deterrence here. I think that Stephanie Current has been captured by a type of criminal thinking that is marked by that lack of insight. I think that when she's on her own, thinking to herself, the rumination she has about this case is, if that guy didn't rear end me, none of this would have happened. I think that's what her main thought process is on this. And that's the thought process of someone not inclined to change. And when we see that thought process in a 65-year-old woman with decades of this same sort of history, the same offense, is putting people in danger by getting behind the wheel with substances in you, by being impaired, that's a huge problem. She's not a young 20-some-year-old with a developing brain where she might grow out of it or something like that. And that's why I'm asking for 4 and 4 out, because I think that's my best shot at trying to protect the community. The best shot I have of impressing of her the significance of her actions, because I don't think she's going to reach that conclusion on her own. And with also impressing with the public the general deterrence of this, that, we don't ratchet penalties down as you get more and more OWIs and commit them in a more aggravated way. We ratchet them up. She's 65 years old, Judge, and she's snorting drugs with biker friends without asking what they are. And that's what she's admitting to. It's one thing to do that and stay home and not make it anyone else's problem. It's another when you get on the highway with a 2-year-old in the back of your vehicle. So for those reasons, I think it needs to be higher than 3 and 3 out. Thank you.
All right. So how are you asking me to? What are you asking per count?
4 and 4 out on the OWI, 3 and 3 out on the bail jumps, those all concurrent to the OWI.
So 4 in, 4 out with 22 CF 252, count 2, 3 in, 3 out for each of the felony bails, all concurrent to each other.
Yes, and even that recommendation isn't a max recommendation. Thank you.
All right, thank you. Ms. Erdman, argument and sentencing recommendation,
Your Honor, our
please.
request is the mandatory minimum of 18 months on the OWI. And then for the felony bail jumps, we would ask for 1 year concurrent on each. Ms. Current, when I met her, had a pretty strong belief, and a lot of it is true, what the district attorney has stated. So from her perspective, the gentleman that hit her car was someone who was operating without a driver's license and had a accident just I think it was a few weeks prior, had totaled out his own car, was actually driving someone else's car. So from her standpoint, this did, precipitate from someone else's behaviors. And I think the thing that we struggled with in coming to some type of a resolution was that there's a strict liability or a mandatory, if you've got something in your system, if there's something in your bloodstream, then you can be found to be guilty regardless of when it got there. And I think that was probably the biggest thing that we needed to overcome. And once I was able to explain that to her, following, I think, the suppression hearing, it was then that she conceded that there was the basis to enter a plea and did so. So prior to that, I think there was kind of a impression in her mind anyway, that she hadn't used anything that day, therefore she couldn't have been under the influence, and therefore this was an unwarranted charge. So regardless of how we got there, we're here today. Ms. Current, I think, is someone who has a history of emotional and mental health that dates back to childhood. She also has a criminal history that, please note that the last OWI was back in 2011. So it is a little bit dated. It's not as though she's someone who's really had just the string of mal-occurrences as of recent. Based on the law as it stands today, Your Honor, she's not no longer eligible for a driver's license. And so we don't need to worry about protecting the public in that regard. And so I think the question for the court today, right, is how do we impress upon Ms. Current that behavior such as this isn't able to be tolerated, and also make sure that we've got the public being protected and addressing any needs she has in terms of rehabilitation. The substance use, I think she is able to avail herself of programming in the community. She's a 65-year-old woman who's not going to have a driver's license any longer. Her very good friend Tim is in the courtroom today. Tim is sober. Tim does not have any criminal history. I think he said maybe a driving ticket, if that, but he's got very good judgment. He's been very supportive all along of her, and I think she does have some good influence in her life. One of the things that I'm not clear if the most recent letter came to Your Honor or not. She pointed out that she's got a granddaughter, a daughter, and that, at her age, they're literally all she's got left. When we met yesterday, it was quite a long conversation about loss, and she had, I think, her parents within a year. That occurred not that long ago, and I think she mentioned maybe seven people had passed away, in a relatively short amount of time. And she basically is viewing herself, her daughter, and her granddaughter is pretty much all she has left. And then she's, of course, got Tim, who's a very close and good friend. So with all of that, Your Honor, I think her mental health, her medical health, also, she's got a hip that needs to be replaced. There's a number of things that probably need to be addressed. We do believe that is able to be addressed in the community, given her lack of, prior convictions for drug charges. 2011 till today, we see a couple of disorderly conducts, but not, meth use, meth distribution type charges. And then also the dated history. the protection of the public at this point, with the lack of driver's license and everything else imposed, having her on some kind of supervision could certainly achieve the goal of sobriety. And then finally, the need to kind of impress upon her that this isn't acceptable level behavior. And Your Honor, given the circumstances from her perspective, I guess, one could argue that there's a lack of accountability, responsibility. And then I think hopefully one could also kind of get in the same mindset of if it's in your system from days past and days prior, it could be hard to maybe appreciate that that's the case. So all of those things considered, Your Honor, that would be our request to the court. Thank you.
All right. Ms. Current, I am now going to turn to you, and this is your opportunity to provide any statement that you wish to provide to the court. Anything you would like me to consider and to know. You don't have to tell me anything. You don't have to provide a statement, but this is your one and only opportunity to do so. Ms. Erdman, you stated something about some letters or some things. If I received some letters, I didn't receive any letters or any information.
Judge, I mean, it was perhaps just directed towards me, and I think we've covered it. So I don't think that there was anything, unless, are you reading to her that letter that you, is that what you? Okay.
All right, if you're going to read a letter to the court, Ms. Current, please do so slowly and enunciate your words, because I have a court reporter who needs to take everything down, okay?
Okay.
All right, and please speak very clearly into the microphone.
Do you want to read it or do you want to?
Hi.
You want to?
There's been a lot said about me today, and obviously I don't see that any of it's true, and makes me sound like I'm out there doing drugs and getting drunk and throwing my granddaughter in the car saying, let's go for a joyride. And that's not how I live my life. I live a quiet life alone with a cat. I don't have company or visitors. Almost all of my friends and family died in 2017. So I've been alone, and I've become accustomed to this. And it's how I prefer to live the remainder of my life. I do have a daughter I'm pretty proud of raising, and a granddaughter I adore. My daughter graduated valedictorian and is now 25, and she started her career in accounting. Her road has had bumps, but I've always been able to insert myself in her life to guide her through. She and her daughter are the only things left of my family. And with my age, I fear I have very little time with them. Taking my granddaughter to the beach on the first day of summer in 2022 was my only goal for that beautiful day. Then someone hit me from behind and totaled my car. It's devastating how in 1 nanosecond, life went from sunshine with a happy little girl to everything being destroyed due to this incident. I lost my home, car, income, and my perfect quiet life I strive so hard to obtain. I don't drink or do drugs, nor do any acquaintances I have, which are few. And people that I do know are not involved with drinking or alcohol. That's not how they manage their life. 2 days prior to this incident, I made the mistake of taking someone else's Adderall. She said it would relieve my pain. Since this was in my system, I'm being accused of driving while intoxicated, and it has ruined me. I don't believe that I was intoxicated that day, or my judgment was impaired. Because this was 2 days prior to that.
Well, then I'm going to stop you. Why did you test positive for methamphetamine?
Because it stays in your blood system, I've heard, for about 30 days, I
You didn't
think.
test positive there's amphetamine and methamphetamine tested positive.
Yeah, I don't understand that. And I just took this
Didn't
substance.
know what you were taking.
No, she just said it was for my pain. I'm in chronic pain all the time. My spine isn't real. It's made of titanium all through it, and I have titanium hip and I have a titanium knee, and I got to get another hip, and it's been a struggle for the last 15 years, but I'm managing. And then that one incident that the district attorney is talking about, when I had morphine and something else in my system, I was prescribed that was prescribed, and a pharmacist went on the stand to tell them what exactly was going on, and I was within my legal limits of my prescription. And I couldn't take the field test because they wanted me to stand up and walk, and I couldn't walk at the time because that was right after my knee surgery. And I couldn't keep my balance. I didn't have my balance then. And I was actually following the ambulance to the hospital because my mother had a stroke. My cousin couldn't drive me because she had treatment that day. She had cancer. And so she had a treatment that day and she couldn't drive me. So I had to drive myself because I wasn't going to let my mother go to the hospital and perhaps die without me being there. So that's what I was doing that night. And I got pulled over because it was a freak storm that we always have. But I answered to that. And I don't see why something I've done since I was 3 years old should pertain to today or to that day 2 years ago. I'm fighting for my life here because I don't believe that I have much time to do that. I don't know where I was at. Taking my granddaughter to the beach. My perfect quiet life that I strive so hard to build. And I don't drink or do drugs, and neither do the people I know or that's involved with my life today. I don't know anybody that goes out there and has a heyday every weekend or every 3 days or whatever. Those are not the people that I surround myself with. I donate blood on a regular basis. I do things for AMVETS. I have a number of charities that I try to help, even though I'm a charity case in itself. This incident is in no way a daily routine or ritual that is part of any of my days, just a singular occurrence. 15 years ago, I made the mistake of intoxicated driving and went to prison for 3 years. Not to minimize this sentence, but I'm only human and mistakes are made. It's about how we as individuals deal with these mistakes that matter. I have not been in trouble for 15 years because I refuse to let that behavior reoccur. So I've made changes. Now I don't know what to do except reestablish my roots, regain control of my life, and it's achievable, but not from a jail cell. I'm 65 years old, not 20, 30, or 40, and I have no family that I can fall back on. And I just live a very different lifestyle than I did 15 years ago. I've worked hard for my life, and I want my quiet life back. I lost my husband 3 years ago, and I've had several spinal surgeries. And now I need another hip. I've been in jail since last January, living in agony with a dislocated hip and not even being placed in a handicapped cell, even though they are available. It's been difficult to say the least. And especially when I think of how this all started one sunny summer day at the beach 2.5 years ago. I'm asking that you take these things into consideration when making your decision. I have a granddaughter that I want to watch grow while I still can. I have medical needs that I need taken care of, and I made a mistake, but I don't believe this mistake should take me away from enjoying the rest of my time left on earth. Thank you for your time.
All right, thank you. Mr. Schmidt, please state again what was detected in her blood from snorting the unknown white substance.
So for the court's knowledge, Adderall is a combination of dextroamphetamine and amphetamine. What was detected in her system was benzodiazepines, which wound up being the alprazolam, which is Xanax, methamphetamine and amphetamine. So Adderall does contain amphetamine. Adderall does not contain methamphetamine.
And that's what, but methamphetamine and amphetamine were both detected from her blood draw, correct?
Yes, 120 nanograms per liter methamphetamine and less than 40 nanograms per liter amphetamine.
And and I'm not a scientist, but I've been doing this job for quite a bit. I've been on this chair for almost 8 years. And when science is, when you hear about science and they detect and they detect methamphetamine in a system, not amphetamine, and the lab analyst goes and does their spiel and talks about what they detect in blood, and they say that they've found methamphetamine, that means that there was methamphetamine in that white substance that you snorted, not just the Adderall and not just that the amphetamine substance in there. So there was methamphetamine in that white substance that you snorted.
I wasn't aware.
I know you weren't aware, and that's what makes it completely dangerous. That is completely so unbelievably dangerous. And that's why Mr. Schmidt is so spot on in his argument where he says you have a lack of insight in the danger that you could cause not only to yourself, but to others and to your poor little 2-year-old at the time granddaughter. You are a danger in the fact that you snorted a white substance that you had no clue of what it was. No clue. It contained a bunch of things that you had no idea of what it was, one of which was methamphetamine, which was detected in your blood draw. All right? So this is a serious case, Ms. Current. This is a very serious matter. You are here in front of the court for a serious sentencing. You operated a motor vehicle while having restricted controlled substances, not only medications that you were saying that you were prescribed, all right? Restricted controlled substances within your bloodstream, within your system, while you operated a motor vehicle with a 2-year-old child in that vehicle who could have been injured or killed, all right? Who could have been injured or killed. Very serious. And this is, you have been convicted now of a 6th offense, And this doesn't even consider that Washburn County matter with that morphine, because that doesn't even come into play. All right. I won't even get into that of whether or not you were prescribed that, whether or not you legally took that morphine, or whether or not you should have been convicted or not. But I will go and I will address a statement that you made. You are so oblivious. You are so oblivious to life and to safety and to the world. And I'm going to tell you, because you said, I'm prescribed these medications. I can take these medications. I'm prescribed these medications. You sure may be prescribed these medications. It doesn't make it safe to drive. while you take these medications. Do you know that they have these little things on medications that say, hey, don't drive, don't operate heavy equipment, don't do these certain things because you could kill somebody. All right? That's what they say. Don't do these things because you could kill somebody. So the fact that you were prescribed morphine in Washburn, and I don't know what happened in that case because that's not here. If you're prescribed Xanax, you can't drive. You can't drive. You're not supposed to drive. It's not safe. If you snort Adderall that has methamphetamine in it and other substances that you don't know what's in it, you can't drive. You're going to kill somebody, including your 2-year-old daughter or granddaughter. It's not safe. And I'm going to tell you, it's not that guy's fault who rear-ended you. It's not his fault. 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 You have to understand, it's not his fault. You snorted the substance. You got behind the wheel. You drove the car with your 2-year-old granddaughter in the car. You got into an accident. It's your fault. It's your fault. It's 100% your fault. You caused all of it. It's your fault. The law is quite honestly very clear. You cannot get behind a wheel. You lack insight of how your conduct and behavior affects others, of how it even affects you. You took a substance that you had no right to take. You did not know what it was. It could have contained fentanyl. You could have died. You could have died on the spot. I heard you. You said you should have died. You could have died. And should you have died? Would that have been great for your 2-year-old granddaughter to have her grandmother die? Probably not. And I don't think you mean that. I don't think you mean that you should have died. I don't think you would have liked your daughter to have had her mother die. I don't think you wish that your granddaughter would have had her grandmother die. I think that you just don't want to be accountable for your actions. I just don't think that you want to accept the responsibility of what you have done. All I hear is excuses, 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 and no accountability. You're consistently avoiding accepting and taking responsibility for your actions, and you continue to make justifications and blaming external factors rather than acknowledging your mistakes and actually doing things to correct them and saying, you know what? I understand what I did. I did something wrong, and I'm going to change that. You did something wrong, and it was your actions. 100%, Miss Current. You are in orange, sitting in that chair for your actions, not for the individual that rear-ended you, not for his actions. He may have played a part in the downfall of Miss Current, but he did not cause you to go to prison. You caused you to go to prison. Only you. And you're shaking your head up and down because I think maybe you're actually realizing today, or having a little bit of insight, maybe perhaps a little bit of insight, your actions have brought you here today. Only you.
I understand that, and I understood that. I've been understanding that. I've been here almost a year. I know.
And that is the first step. The first step to healing. The first step to trying to reach some point in sobriety. I have to look at multiple things when I sentence. And I have to look at the nature and the gravity of the offense. And here it is so very, very serious. It is so serious because it is an OWI 6th offense. And I have to look at you, and I have to look at your character and your past criminal record. And again, this is an OWI 6th offense. And then I have to look at needing to protect the public, and I have to look at rehabilitation and if there are ways that you can rehabilitate. And that means that I have to look at if you have completed treatments, if you have the ability to go to treatment, and if you have the ability to have a path to treatment. I also have to look at other things, as Mr. Schmidt has pointed out. I have to look at, is there what's called an undesirable behavior pattern? Have you engaged in these types of actions and conduct and behavior before? I have to look at your culpability. I have to look at your age. I also have to look at your history. I have to look at deterrence. I have to look at specific deterrence. I have to specifically deter you from continuing to do things like this. This is an OWI 6th matter. There comes a point where I have to have a sentence that says, Stephanie Current, you cannot continue to do this. Enough's enough. Is this sentence going to be enough? It's enough for you to stop continuing in this path, in this destructive behavior. I have to look at general deterrence to say to the public, you cannot engage in this type of behavior and conduct because you will go to prison.
Judge,
Yes.
just so that the record doesn't get confused in any way, and I know the penalty structure is the same. She pled to an OWI 5th. That's what's in the court minutes. That's what's in the.
Oh, it's the
questionnaire.
5th, not the 6th?
And I just want to make sure that we get, or stay aligned, but I do acknowledge it's the same.
All right, so it's the 5th, not the 6th. I wrote down the 6th. I thought Mr. Schmidt said it was the 6th. All right, thank you, Ms. Erdman, for that correction. It's the OWI 5th. She originally was charged with OWI 7 and 8. Then it was amended down to 5th and 6th due to her history and all of the other things. All right, thank you for that correction, Ms. Erdman. I appreciate that. We do need to make sure that it is all correct for the record. So an OWI 5th. Now, this is something that carries a mandatory minimum, and this is an OWI 5th now with a minor. So there is that mandatory minimum where the court has to first look.
I'm sorry again, and I don't mean to keep interrupting. The child enhancer was dropped.
Oh, that's right. Well, and that's right. That's where it was not dropped on here. And is it not dropped
It's not
on the
dropped in
amended?
PSI, the
It is not,
notes say that. the
it is
state
not
was-
even dropped on the amended information.
The notes say that the
We
state.
amended
was-
it at the plea and sentencing.
Okay, and so it wasn't
Please.
even, that's the issue, and that's why the PSI got all of this. That's why it was all incorrect and wrong. Okay, so that's all of the confusion. Okay, anyway, this was an OWI 5th. It still had a 2-year-old involved, even though this is a mandatory minimum of 1.5 years of confinement, a mandatory minimum with extended supervision. This still had a 2-year-old in the vehicle. It has a maximum possible penalty with this OWI. Mr. Schmidt is indicating that this is a more serious matter and that the court should look at this as a more serious matter due to the history of you, Ms. Current, and the fact that it has the 2-year-old in the vehicle, and looking at your history with your past OWI history and your past as it relates to your treatments, your failed treatments, your refusal for treatments.
I never refused treatment.
You've never refused treatments.
No.
Well, that was just a statement made by the district attorney. Either way, I have to look at this matter and it is serious. It was originally charged more serious and through the grace of God and the arguments of your counsel and through strong negotiation, all of those enhancers and the original charges from OWI 7-8 and the enhancer with the minor was all worked out and taken off, and it was modified down to a simple OWI 5. So the exposure that you have is much less. If I'm looking at this matter, Ms. Current, again, it is extremely serious. You have multiple past OWIs. I have to look at the specific and the general deterrent and the fact that you have a lack of insight and the fact that even in your statements to the court, you don't take accountability. Your first statement, you come out and you say, you don't think it's true, that you wouldn't be here but for the fact of the individual who rear-ended you. You don't do drugs. You didn't know that this was Adderall. You only do your medications. And all of this is just excuses and excuses with no accountability. I have to look at needing to protect the public, and you have an extensive history of not protecting the public, of not doing what you need to do to make sure that you do not put the public at risk. If that guy didn't rear end you, then this wouldn't have happened. But again, we see that that is not even accurate or true. And when you had posted bail and you were released from custody, it wasn't that long, and then you were then again violating the law. Thus, the felony bail jumps. Again, the public at risk.
I was here that first bail jumping. I was just late that day, and
I'm
you,
not talking about missing court. I'm talking about when you were operating the vehicle.
yeah,
That time. Not missing court. That doesn't put the public at risk. So the court needs to look at the rehabilitation, Ms. Current, and I need to look at the confinement. And there's a mandatory minimum, and I'm looking at the stronger argument is for the state. I have a recommendation from the Department of Corrections with 3 in and 3 out for actually for all of the charges. The state is arguing for a stronger argument of 4 in. for the OWI and 3 in and 3 out for the felony bail jumps. Your attorney is arguing for a lesser sentence for all of them, saying, be lenient, let you out. You've learned your lesson. But all I hear from you is excuses and not taking responsibility or being accountable for any involvement.
Excuse me.
No, I'm done hearing excuses. I'm done hearing,
Not excusing myself.
yes, and you keep interrupting me. You keep interrupting me, and I'm not hearing anything else, and it's not going to change my mind. All I hear is the fact that you may have learned something now, and today may be a day that you've finally decided that your actions did play a part, but you have impacted the public, you've impacted yourself, you've impacted your granddaughter, and you've put everybody at risk. And I think that the only way for you to be able to learn a lesson, for the public to be able to learn a lesson, and for you to be able to rehabilitate is for you to serve time in prison. And so the court is going to sentence you to, I'm going to actually follow the recommendation of the Department of Corrections, 3 years. Initial confinement, 3 years of extended supervision for count 2 in 22 CF 254. 3 years initial confinement, 3 years of extended supervision for 24 CF 101 felony bail jump, 24 CF 101 count 2 felony bail jump, 3 years in, 3 years out. So all concurrent. I do believe that Mr. Schmidt had a very strong argument for the OWI, having a harsher sentence of 4 years in and 4 years out. But I think 3 years should be enough for you to figure it out. And it's I'm not going to make you eligible for the challenge incarceration program due to your age, and I'm not going to make you eligible for the substance abuse program. This is going to be 3 years that you must sit in an entirety, because this is 3 years that you're going to have to sit, and you're going to have to sit in its entirety and figure it out. Because this is 3 years that you're going to have to learn to be accountable. With regards to the felony bail jumps, $518 in fines and fees each. With regards to the OWI, $3,954 in fines and fees, DNA surcharges, plus a $10 blood draw fee. You have $5,000 posted. That covers all fines and fees and blood draws. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. Well, actually, I'll hear as to substance abuse.
I was just gonna ask Judge, so by my calculation with jail credit, she has 325 days. The minimum she must sit, because she doesn't get a break, is 547. So that would give her an additional 200 days yet that she wouldn't qualify. In terms of the programming, right? I think it's been a very long time since she's had it, back in early 20, I think it was early 2000, that was the last time she'd been in programming. Arguably, I think she could benefit from that.
Mr. Schmidt?
When I talked about her refusing program, I was referring to the bottom of the second paragraph on page 9, when it indicates the last time she was in prison, she refused the program.
All right, so that makes sense. So if she refused programming in prison, I will give her the option to do programming in prison. So I will make her eligible for the substance abuse programming after she has completed the mandatory minimum of 1.5 years of incarceration. And then she will have the option to actually do substance abuse programming after that. And that will be at her choosing, or she can refuse after that. 20 days to appeal. Should he fail to appeal after, should she fail to appeal, she loses the right to appeal. This is a felony, no use or possession of a firearm for life, no voting in any elections until her civil rights are restored. She has fully paid all of her fines and fees on all matters. The court is ordering her DNA. The jail will make sure she takes that. Extended supervision, conditions, absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia. Take medications as prescribed. No bars, taverns, or liquor stores. No alcohol. The court is going to revoke driver's license permanently. No casinos. Any other conditions you see, Mr. Schmidt? How many days of jail credit?
She works at casinos. It's
Except for, no casinos except for employment.
325.
325 days of jail credit.
That's it.
Other conditions that you see necessary? Regular drug testing. All right, then we are adjourned.
Stephanie, this says that you want to appeal, right? You said to me today, I know I want someone to look at my attorney's work, the judge's decisions, and I want to appeal. I do not want to appeal, or I haven't decided about appealing yet, but I know I need to tell my attorney within 20 days my decision. You want to do that one? And then you said your name on that one.
Ms. Hess, do you have your driver's license? Where are you in the process of getting your license? Fill out the half price. Go get the half price. Do you know you can fill out a half price form? You can fill out a half price form. All you have to do is get the intox lock.
Yeah, according to that, because I already did my assessment and I'm going to AODA council.
All right, what I'm gonna do is I'm going to reschedule you to January 3rd at 1:30. And if you get your intox lock, well, if you get your, go fill out your form for the half price intox lock, you can get it from Amy.
Okay.
And then file that, and if you get your driver's license by January 3rd, give it to Mr. Schmidt, and then you won't need to come back. Okay? It'll be reset to January 3rd at 1:30, but again, if you get your driver's license before then, bring it to Mr. Schmidt.
Well, she'd still have to come back because the offer was to plead to the THC.
Oh,
if
it's
she
still,
did that.
oh, no, then come back on January 3rd.
Okay.
So, but go fill out that form and file it, then January 3rd at 1:30. Okay, thank you. Can you just move it to January 3rd at 1:30?